Shall we begin, sir?
Yeah, please.
Okay. So it's a great pleasure that Professor N. Bartow has agreed to deliver a talk in the webinar, which is titled as Copyright Law and the Feminist Gaze, as sir has mentioned, that it is not, a kind of topic which is very common. So everybody has some curiosity, and I'm not going to disclose anything about that to make it very, very, you can say thrilling in that sense. So we welcome you, ma'am, on behalf of Campus Law Center Legal Aid Society, which is a society which is catering, the needs in this very pandemic time. Providing awareness or generating awareness about the legal rights and all that. So it was pretty aligned to our society also, because we are doing something which empowers those who are disadvantaged. So in that sense, because it is pretty secret what you are going to talk, but there are some guesses. One of the guesses that when we talk about intellectual property, we are more aligned to the rights which are being very exclusive in that sense. We just go by the subject matter which is being provided in that way. We don't look at it in an inclusive way as regards to the participation of the people, may it be inventor, may it be creator, whether they are being included in that very thread or not. So that is sometimes missing, because we are so engrossed in recognizing those rights that we don't pay that much heed to that. Number one. Number two, there may be, in the subject matter also, which usually copyright covers, how it reflects the various segments of the people. So one of the clues which I get is that you must be, emphasizing upon that how women has been reflected under the copyright regime. And the next thing is how they could, they have been empowered in that sense. So because, I don't want to reveal anything about that, so that it would be interesting. I'm just going by a very short profile of yours, which is well known to everyone, but for the sake of just formality, I will be doing that. So Professor N. Bartow, she joined the UNH Law to lead the Franklin Pierce Center for Intellectual Property in 2015. And I'm just quickly, highlighting her area of expertise. So her scholarship focuses on the intersection between intellectual property laws and public policy concerns, privacy and technology law, and feminist legal theory. And she has published numerous articles and book chapters on these subjects. She can speak in widely in the media on the topics of copyright law, trademark law, internet law, and feminist legal theory. So I will emphasize the last one because it is pretty relevant to our talk. So with this very note, I invite Professor N. Bartow to begin with her talk.
Okay, so it looks like I need to do the share screen again. So just give me 1 second. Oops, I have a message that says host disabled participant screen sharing. So I can't, oh, here we go.
I will be doing that. Yes.
Okay, here we go. Good, perfect.
Yes.
Okay, well, thank you very much for your interest. I'm really excited that you're interested in this topic. I have to say there are some legal scholars in India that write about intellectual property and cultural property. And there's definitely some gender issues. There's definitely some folks that talk about gender issues when they talk about cultural properties. So that's, I think, very exciting. And there's a lot of work that gets done, but it's not always linked as directly to intellectual property. It's sometimes I call it intellectual property adjacent. Things like privacy law can have a huge impact, a huge gendered impact. So people write about it as privacy law. So sometimes there's sort of feminist or at least gender issues beneath the surface that we're not always aware of. I wrote this. This started as an idea and then became a book chapter. There's a woman named Irene Calbally. She's on the faculty of the Texas A&M Law School, but she lives in Singapore. Her partner also has a job in Singapore. So she has visited at the National University of Singapore and the SMU, the Singapore Management University. And she does a lot of international work. So she decided it would be great to have a book, to do a book called A Handbook of Intellectual Property Methodologies. And her idea with the methodologies book, which is at press, it's not out yet, but it's getting there pretty soon, was to just recruit a bunch of scholars in intellectual property who had specific interests that were not linear. They weren't just like the regular sort of economic analysis of intellectual property. So she recruited a bunch of folks to do different issues. So the methodologies chapter has looks at race, it looks at economics, it looks at development issues. So there's a lot of things in there. There are a lot of really interesting chapters and a lot of terrific authors. So I was excited to be part of that. And Irene asked me to write about copyright law and talk about methodologies. Well, feminist methodologies was my charge, not just particularly copyright law, although that's what I'm focusing on here. So my task, my charge was to explain how you would do a kind of a feminist analysis, a feminist legal theory analysis of copyright law. And so that's what I'm gonna tell you. Okay, there we go. Okay, so I use the phrase the feminist gaze because there's a feminist film theorist named Laura Mulvey, and she is best known for an essay she wrote that's very famous. It's been around a long time, and it's called Visual Pleasure in Narrative Cinema. And in that essay, she articulates what she calls the male gaze. And the male gaze that she asserts, Mulvey asserts, that it is gender power asymmetry and that it's a controlling force in cinema. And that movies and television shows too, that movies are actually constructed for the pleasure of the male viewer. Usually because it's men who are directing and oftentimes writing, but even female directors sometimes pulled into this, that they construct these artistic works for the pleasure of a male viewer, which is deeply rooted in patriarchal ideologies and discourses. So what she says is for almost most of the entertainment products that we see, the male viewer is the target audience. And then women are there to be the bearers of meaning rather than the makers of meaning, which is what men do. And that females are usually not permitted to take control of a scene, but they are there to be observed and objectified. One of the things, and I don't know if you all watch too much American television, but in American television, there's a television show that's very famous called Seinfeld. And in Seinfeld the characters are mostly men, and then there's one woman, the actress Julia Louis-Dreyfus plays a character named Elaine, and then there's Jerry, all the male characters. And so she's a fantastic actress, and she held her own in that series. But a lot of people will look at other shows, and there's something that everyone calls Seinfeld syndrome, which is where you have a bunch of really talented people, and most of them are men, and then there's like one woman or at most two women, but the men always outnumber the women. So that's something that's very common when you look at popular television shows in the United States. The Big Bang Theory is very popular for a few years. It's the same idea. For a while, they barely had one female character. Now they have three, but of course there are four men, and that's just very typical. So Laura Mulvey talks about the male gaze, and not only is it a matter of numbers, but it can also be just a matter of kind of respect and presentation. So here's an example, it's just a clip from a movie. It was advertising a movie, and the male gaze theory holds that women in visual media are viewed through the eyes of heterosexual men, and they're representative passive objects of male desire. And audiences, all of us, are forced to view women from the point of view of a heterosexual man, even if they are heterosexual women or homosexual men. This affects how men look at women, how women look at themselves, and finally how women look at other women. So if you look at the photograph, you can see the man in the picture gets to wear sort of regular clothes. He gets to wear jeans and a t-shirt with a shirt over it. And then the women are very scantily clad, right? They're all in bikinis and showing off a lot of skin, very body conscious stuff. And it's very typical when you see this. Men often get to wear clothes, different kinds of clothes, and women are usually half naked or have to wear very body conscious clothing. And that's, again, that's a sort of a manifestation of the male gaze, that because this is what heterosexual men want to see, it's viewed as this is what everyone wants to see. Okay, so I just co-opt the idea of the male gaze to become the feminist gaze, and I choose to use that to look into the roles that women play in the different contexts and how they're affected by processes and outcomes. So just to start, so there's a philosopher, many of you have heard of, I'm sure, named Simone de Beauvoir, and she wrote her most famous book, The Second Sex. And in it, she talks about the way that men fundamentally oppress women by characterizing them as the other. So women are always the other, men are always the standard, and women are others. And you can see how this maps on Laura Mulvey's theory, right? The men are the standard, so all the movies and television shows are made for their view, and women can kind of push the plot along. We're happy to take your money if you're in the audience, but they're never the target audience. So man occupies the role of the self or the subject, woman is the object or the other. Man is essential, absolute, and transcendent, while women are inessential, incomplete, and mutilated. Man extends out into the world to impose his will on it, but women are doomed to immanence or inwardness. Men create, act, and invent, while women wait for men to save them. So this is sort of the construct that she talks about in society. She says that one is not born a woman, but becomes one, right? And that's the great nature-nurture debate. So she says you're not born a woman, but you're culturally pressured, that the way that women sort of turn out has a lot to do with the way that we're raised and the way that we're socialized. And she identifies the economic underpinnings of female subordination and the economic roots of women's liberation. And she argues that only in work can women achieve autonomy, because if they can support themselves, women can achieve a form of liberation. And then finally, in the concluding chapters of The Second Sex, she discusses the logistical hurdles that women face in pursuing this goal. So I kind of take it from there, right? Because to be an inventor or an author, involved, even an intermediary involved in intellectual property, is potentially a means for the economic independence of women and women's liberation. So that to the extent we're shut out in a pretty big way, right? That's exactly the logistical kind of hurdles that she's articulating. Okay. So basic feminist legal theory, sorry, I just jumped ahead a little bit too much there. Back. Yep, sorry about that. Okay, so basic feminist legal theory actually starts very simple. You shouldn't be like, I don't know if you are, but law students get sometimes intimidated by this idea of feminist legal theory, like there's something really complicated and different out there, and that would be very hard to become up to speed. When in fact, it's actually, you can start like entry-level basic feminist legal theory is just about counting things. It's just about noticing situations in where women are overrepresented or women are underrepresented, right? Like Seinfeld syndrome, where you just have one woman. You just start noticing it. Like you may not have noticed that in your life, but once you start noticing it, you can't stop. You'll notice it everywhere, that there are these imbalances. So basic feminist legal theory just starts with noticing these disparities, just counting bodies, like who's in and who's out. And then from there, you sort of theorize differences, like how did this happen? Why did this happen? Could we solve it? What's the impact? And ultimately explaining how to address and fix inequities. So to just give you an example from US law that's not intellectual property law, which is very straightforward, is there was an act that was passed in 2009, the Lilly Ledbetter Fair Pay Act of 2009. That was actually when Barack Obama was elected president of the United States in 2008. He took office in January of 2009, and this was the very first law he signed into law, the very first piece of legislation that he signed was the Lilly Ledbetter Fair Pay Act. And what happened was Lilly Ledbetter was working in an environment with a lot of men, and she held her own. She always got very good job reviews, and she worked hard, and she worked there for many years, and she kind of moved up. And then one day she found out that all the men that she was working with, even some of them with less seniority and less good job reviews, were getting paid more than she was. So there didn't seem to be any reason for that other than gender. So as soon as she found out that she'd been paying less, she also found out she'd been paid less for years and years and years. So she brought a lawsuit, as was her right, and she did okay for a while, but ultimately it was argued up to the US Supreme Court and in a pay equity action, and she lost. The justices went against her. The late Justice Ruth Bader Ginsburg, who is a kind of a feminist icon in the United States and who recently died, she had a big dissent, right? She was all for women's pay equity, but she couldn't carry the day. So in response to that, Congress passed the Lilly Ledbetter Fair Pay Act, and they were able to put into law what the court wasn't willing to do. So there's actually a law now that, that women can sue retroactively when they find out that they've been paid less. So just an example of the thing, that's a classic example of feminist legal theory, right? Lilly Ledbetter noticed she's paid less, and then it's argued in court, and that didn't work. So the B plan is to go ahead and try to get legislation that addresses the same issue, and it worked. So it's like a success story for feminist legal theory. So women, not just copyright, women are underrepresented in every area of intellectual property. So we can start with patent law. Fewer women than men are inventors. Fewer women than men are patent agents or patent lawyers. Fewer women than men are patent examiners at our USPTO. There are fewer patent litigators, district court judges where patent trials happen, and then federal circuit judges. So basically in every single legal job related to patents, and then every single scientific job as well, inventing generally, there are fewer women. And it's not clear whether it's cause or effect or maybe both, but fewer women who apply for patents are successful. And when their patents are rejected, women's applications are 2.5% less likely to be appealed. So I just want to stop there. That may not be the women's idea, right? A lot of times inventors work for a corporation, and someone in management will decide, you know, whose applications if they're rejected, whose applications will be resubmitted. So it's not clear that the women are saying, oh, I give up at a higher rate than men. It may well be that the people supporting them give up and don't give them the resources or the permission to go ahead and apply. I don't have the data on that. I don't think anyone does, although we're getting more data about these questions, which is terrific. In any event, when applications are granted, women's patents often had more words added that reduced the scope of their patents. So I don't know if you all have patent backgrounds, but when you have claims, the claims of the patent are basically, the claims of the patent are what you own, right? They're like the metes and bounds of the patent. So if you're looking at what a patent gives you, it's the claims. When words are added to the claims to make by the patent examiner's request, it will narrow the scope of the patent usually. So basically when words are added to the claims, it means the patent gets narrower, the claims get narrower, and when the claims get narrower, you own less, right? So the narrower the claims, the less that the patent covers. So it just turns out that when women's applications are granted, their patents have more words, and that reduces the scope of the patent, makes them less valuable. So even when approved patents fared poorly, women's patents are maintained less often by their assignees, the patent owners, which again would usually be a corporation, and they receive fewer citations from other inventors and from patent examiners. Something weird is going on my screen. I'm not really sure what the lines and the dots are all about, but I'm just going to go ahead and move to the next slide. Oh, it's still there. I'm not sure why that's there, but okay. So we have simple statistics as methodology. In patent law, women inventors account for just 13% of patent applicants globally. The percentage in the United States is similar. I actually would be curious what the percentage is in India if anyone knows, but it's about 13% globally, and again, the United States mirrors that. The gender disparity among inventors gets even starker when one takes into account the fact that most female inventorship takes the form of a lone female on a male-dominated team. A few minutes ago, I was talking about Seinfeld syndrome, where you had Elaine with a bunch of male actors. And here in patent law, the same thing, that often when there is a woman who's an inventor, she will be the only one, or there'll be fewer women than men on male-dominated inventor teams. Women, when they're trying to go it alone, have trouble raising money to patent and commercialize their inventions. Companies founded solely by women received just 2.2% of venture capital funding in 2017. Companies founded solely by men was over half. So that was, which is a tremendous disparity. Women play invisible roles in research. For example, acknowledged programmers or researchers whose names don't appear at the top of a final paper, but who come up with computer programs were overwhelmingly more likely to be women. In other words, even though women may give invaluable contributions without which the research could not happen, the roles in which women are sent or congregate, whether it's voluntary or involuntary, are the ones that don't get recognized. So they wound up being assigned support status. So they have to do support rather than being in a position that they'd be recognized, even though their work may be just as valuable or in some cases more valuable. Okay. Copyright law. Women are underrepresented in most creative fields, and even in disciplines where there are appreciable numbers of women in the pipeline, the authors who have the most commercial and critical success are overwhelmingly male. You know this, you may not have noticed this before. You'll notice it by the end of this talk. And again, it's something you'll never unnotice or unsee, which is, at least in the United States and most of the world, at least the parts that I can follow that are English speaking, women are just underrepresented everywhere. If you look at the bestseller list of novels, like authors of novels, if you look at publishers, the intermediaries, if you look at music, if you look at who composers are, who's running the music companies, if you look at the artists, the sort of name artists, how much they earn, how much they're on tour, the kind of support they get, anything, opera, symphony, you know, every area of the arts, you will see that there will be a pyramid and that the people at the top will always be men. And that's true with arts and that are traditionally associated with men, but even arts that are associated with women. For example, in many parts of the world, and definitely in the United States, you know, cooking is something that's associated with the domestic sphere and therefore associated with women. But when you look at who are the top chefs, the famous chefs, the ones who get the Michelin star restaurants, and these restaurants get reviewed in impressive places, those tend to be men. Right? Fashion, right? Women's clothing. Women are associated with women's clothing because we buy women's clothing and we wear women's clothing, and women do not design women's clothing. But if you look at the top fashion houses and who rise to the top, who are the famous designers, you'll see even for women's clothing, they're disproportionately men. And of course, for men's clothing, they are too, definitely. Okay, so when you consider patentable inventions or copyrightable works, the rights to the vast majority of the very profitable ones are held by men. So they're not just the faces and the talent that you associate, but they're often the intermediaries and the people running the corporations that hold on to this, right? The Disneys, the big entertainment, the Sonys, the big entertainment corporation. So this causes a host of negative consequences for women. They start and run businesses at lower rates than men, and they very rarely reach elite leadership levels in the corporate world. They're perceived as less competent, less dedicated, and less hardworking, and suffer from a lack of female mentors and female colleagues. It's part of the reason that women earn less than men, even in equivalent positions. And again, we did have the Lilly Ledbetter Act, so that does give you a venue if you find out you're being paid less when someone doing the same job, but that's sometimes very hard to find out and often very hard to solve. Okay. Gender disparities are observable when women and men first begin preparing for their careers. The majority of people attending and graduating from art schools in the United States are women, like studio art, the kind of art that produces artists who make things for galleries and for auctions and for museums, are women overwhelmingly. Men attend colleges and universities in smaller numbers than women in the United States, actually, but they still dominate the so-called STEM disciplines. And STEM, you know, science, technology, engineering. The STEM disciplines are still dominated by men. And beginning in the United States in middle school and high school and continuing through college and graduate school, men are still more likely to major in science, while females are more likely to major in the creative arts. So if we stop right there, we could say, okay, men are majoring in science more, women are majoring in creative arts more. What might we expect to see in an equal society? Then we would expect to see men getting more patents, but we would expect to see women rising to the top of the creative arts because there are more of them, right? So it's proportionally, there would be more at the top, but we don't see that. Even though the U.S. Department of Education has created special programs designed to attract more girls to schools that specialize in math and science, boys continue to outnumber girls in the schools by a wide margin. And for middle and high schools that concentrate on music, fine arts, dance, and theater, there are no citywide programs designed to attract more boys. Consequently, girls outnumber boys at art schools by an even greater margin. So what's going on here is there are fewer girls going to science schools, so the Department of Education sees that as a problem, right? And I think it is a problem. I'm glad they see that as a problem. So they see it as a problem, and they're trying to find more pathways for women into science, which is all good. However, on the flip side, when you look at the art schools that are overwhelmingly girls, no one thinks that not having boys is a problem. No one sees that and said, where are the boys? We have to get boys into the creative arts pipeline. They don't do that. There are no special programs. Why? Girl germs, right? This is seen as a girly thing that's not, you know, that boys shouldn't be drawn into. So there are gender stereotypes and really bigotry against boys and no help for them to bring them in equal numbers into the arts like we have for science. So it's just viewed differently. In this case, the girls benefit from the extra access to science, but the girls that are in the fine arts programs as children are basically being told what you do is not valuable. It's not valuable like science is. We're trying to get you into science because that has value, but the arts is just a thing that girls do. So this slide is about negative spaces. So one of the things about intellectual property and copyright that's sort of a kind of a beginning thing that there's actually a decent amount of scholarship about here and there around the United States and Canada. They talk about negative spaces because when you look at the creative works that are most strongly copyrighted, they tend to be associated with men. And when you look at creative arts that are associated with women in the domestic sphere, they tend to have little copyright or no copyright. So I personally, my philosophy of life and copyright is that lower barriers are actually a better thing, that people, when they collaborate and work together, you actually get more innovation. I know there's a range of opinions on that and a lot of disagreement. But in any event, so what I'm not arguing here is that these areas need more copyright necessarily. I'm just pointing out that we compare works that are associated with the domestic sphere, which is works that are associated with men, and you will see that men get more copyright protection, and it doesn't seem to be an accident. So the first on the list is cooking. And I already mentioned cooking as men tend to rise to the top, but you cannot copyright recipes. You can take a picture of pretty food and copyright that, and you can write a cookbook, and some of the stuff that's not exactly the recipes, right? The introduction, the explanation of the recipe, the little poems and pictures that people sometimes put in cookbooks, those are copyrightable, but the recipes themselves are not copyrightable. And they're not patentable generally either, so they just don't have intellectual property protection. I've heard, stories, lots of people have family recipes that they pass on to each other, that you inherit from people in your family, that you keep secret, from other people. That's sort of your family secret with cooking. So that's a lot of fun, but that's like almost shadow or para-intellectual property when you think about it, right? When you're keeping your recipe cards secret from other people. So there is sometimes even an intellectual property instinct very informally when you think about cooking in different cultures. Second category is makeup. Makeup is associated a lot with women. Men wear makeup and men can wear makeup. They wear makeup in a lot of different situations. For example, in theater or movies. There can be a lot of science fiction characters and really very serious makeup, or just makeup to take people's natural features and try to accentuate them. But it really is an art. If you look at the work that makeup artists can do, and how they can change people. And there's actually makeup tutorials on YouTube and different things where you can learn about makeup. And I'll tell you something, if you watch some of those changes that makeup artists can take people from A to B, that's art. That's like art, that's a lot of change. That's not given intellectual property protection, but those people are painting. It's just that faces are their canvas instead of canvas being their canvas. But I see that as art. Hairstyles, again, everyone has a hairstyle. Even if you don't have hair, that's a hairstyle, right? You've shaved your head. So everyone has a hairstyle out there, and people, especially, actually, I should stop and say with the pandemic, people don't have hairstyles anymore. One of the funniest things about Zoom is seeing your friends with what we call pandemic hair, where they haven't been able to get a haircut in a long time. But when times are better and you get a haircut, people express a lot of creativity and individuality with their own hairstyles, and hairstylists can do a lot of really interesting work, but no intellectual property protection. For a long time, clothing really did not get intellectual property protection in the United States. Some examples would be, my dress has a print. So this print would be copyrightable. This is Marimekko, in case you're curious. I love Marimekko from Helsinki. But anyway, the print is copyrightable, but the cut of the dress or the cut of clothing was never held to be copyrightable. There is a case that came down a few years ago called Varsity Brands, which I'm going to talk more about in a few minutes, but that seems to be a move toward copyrightability of clothing. But up until that point, there's been no real ability to copyright clothing, just fabric. Quilting. So quilting is a craft associated in the United States, associated with women. You make a blanket together, but it's really an artwork. It's made from scraps of cloth, but you make a picture, maybe a geometrical design, other things. So quilting is a form of art, and really, really good quilters can sell their quilts for tens of, sometimes hundreds of thousands of dollars. So quilting is, you would think, because it produces something very much like a canvas, an obvious case for copyright. But in fact, one of the things associated with quilting is people working together. So there's something they call a quilting bee, or like a quilting party, where you'd spread the blanket out and you'd have, 6, 10, 12 people. Your friends would come and all help you make a quilt, and that would be your quilt. And then you go to your friend's house and 6, 10, 12 people would all sit around working on a quilt. So groups of women worked collaboratively on each quilt. And because of that, it doesn't really map well with intellectual property. Because in intellectual property, we like to have one author, or one heroic author, or maybe a couple authors, but certainly having 12 people working on the quilt at the same time and then moving on to the next quilt does not sit well for the intellectual property. Gardens. Again, men and women both garden. Gardens, flower gardens tend to be associated with women in the United States, and vegetable gardens too, I suppose, at least non-commercial ones, like kind of recreational gardening. But in the United States so far, the jurisprudence says that gardens, even though you can map them out, they can be beautiful, you can replenish the plants and really keep the garden looking pretty consistent over time, based on fixation and some other things, the courts have said no to copyright protection for gardens. And then finally, interior design, right? The idea of making your house look sort of ritzy and furniture and spaces and colors and things. Very, very creative. People, study this. They learn about colors and patterns and things to decorate their house. And people pay a lot of money to interior designers, but still it's an area that's associated primarily with women, and it's an area where intellectual property is not availing. Okay, so this is the Varsity Brands case that I mentioned a minute ago, Star Athletica versus Varsity Brands. So in this case, the subject matter were cheerleader uniforms. And I'm not actually sure in India how much the cheerleading culture has permeated. Maybe in the Q&A you can tell me about that. But in the United States, cheerleading is tremendously popular across ages. It's fairly broadly popular, and almost with all girls. I mean, there are boys that get involved, but it's mostly a girl's pursuit. And it actually starts in childhood. And little kids can become cheerleaders, and it's basically a way to get them exercise, and it's almost like a synchronized gymnastics. They meet up with their friends, and they learn little cheerleading routines, but they all have to wear matching little dresses and matching sneakers, and it's kind of expensive. I have 2 nieces that did cheerleading as children, and they always have, because they grow, right? So kids are constantly buying new uniforms as they grow out of their old uniforms, and the matching sneakers, and I know for my sister-in-law it was expensive to constantly be buying these cheerleading uniforms. Once these kids get into high school, then sports, then there are usually it's boys sports like baseball, basketball, or football. The boys are playing, and then the girls take the role as cheerleaders. So they come out and again, matching uniforms, and they have cheers, and they do gymnastics routines. And the idea is to get the crowd riled up, to get the crowd happy, so that they make a lot of noise for the players, and it makes the game more exciting. And it also gives people something to look at during halftime, I guess. Generally attractive women in the attractive girls in high school doing these gymnastics routines in very short skirts. So that's sort of cheerleading in high school. When you get to college, the same thing. Cheerleading in college, again, sometimes there's competitions, and sometimes there are men, because it becomes more of a gymnastic tumbling, and men like lift up the women and throw them, as part of the gymnastics routines. And I'll talk more about that in a second, but it's primarily women. So with that background, Varsity Brands was a company that was dominant in selling cheerleader uniforms. And remember, they can sell them little kids, high school, college, even our professional league, even professional basketball in the United States and professional football have cheerleaders, some of the teams. So to sell cheerleader uniforms is to make a lot of money, right? So Varsity Brands is a dominant source of cheerleading uniforms. They were making just, head over fist lots and lots of money. So of course, what happens, right? When someone's making money, another company wants to compete. They want some of that money. So Star Athletica was making cheerleader uniforms also. And they looked at Varsity Brands' catalog, and they could tell from the catalog and also from what they were seeing when they went to schools, what the people were wearing, that there were 4 or 5 really popular styles of cheerleading uniform, okay? So when they built, when they were trying to compete with Varsity Brands, they knew the only way they could compete and attract clients was if they used some of the popular styles. So the same styles that were already popular with Varsity Brands, that's what people wanted. So to compete, they knew they had to do that. So Varsity Brands, sensing competition right on their heels, applied for copyright protection for some of the popular styles of cheerleader uniform, because they knew otherwise it would be hard to compete. Then they would have to compete on price or quality. They don't want to compete on price or quality. They want a monopoly on the popular styles, and they wanted a copyright law to give it to them. So they filed for copyright protection, and Star Athletica said, wait a second, this is clothing. We don't have copyrights on clothing in the United States. So that was their argument, and ultimately, unfortunately, they wound up losing. So the dispute was about, so the elements, I'll show you a picture in a second, were chevrons, zigzags, and stripes, just very, very simple symmetrical flourishes, or sometimes asymmetrical, decorating cheerleader uniforms. And this case was the first time the Supreme Court had even listened to a case, entertained a case on copyrights and apparel design. And the outcome, which ultimately held that the copyrights were valid, was been heavily criticized. They voted 6-2 in favor of a certain interpretation of provisions of the Copyright Act that said that simple ornamentation to be copyrightable, involving a simple ornamentation, whether it was copyrightable. And Varsity Brands successfully asserted copyright protection for 5 styles of the cheerleader uniforms, basically monopolizing the market because they monopolized the most important and popular styles. So right here at the top, you see the different styles. So you can see they're pretty similar, right? There's the first 2. The one on the left has the triple chevron, and then the one next to it has just the double chevron. It looks the same. The one in blue is just the double. It has one less line, right? There's 2 lines making the chevrons instead of 3. And then in the middle, you see the green and navy blue dress has the triangle, the chevron at the bottom just comes to a peak. And then the next 2 are like that, they're similar. And then finally on the end, so you can see they're all fairly similar. They all have the chevrons and the stripes, basically kind of looking the same. And then the picture at the bottom is a woman wearing one of these, right? So she has wearing one from a particular school. So cheerleader uniforms for your team, whatever your team is or your school, will generally be right on the uniform. So you can see this one says Westlakes across her chest. So when they're made by a cheerleading company, they're customized like that. But that's not what they copyrighted, right? The pictures at the top, the uncustomized version is what they were selling. And then any school or organization that wanted the uniforms would then adopt them and have the logo, the school logo. So the logo was chosen by the school. And then the other thing that's chosen by the school is the colors. So again, I don't know how broadly this goes, but I think in a lot of countries, schools will adopt colors. They'll be like sort of the colors associated with the school. So the University of New Hampshire's colors are blue and white. Other schools, many popular combinations. My high school was red and white. My college was also red and white, so that was easy. My law school was blue and red. Like everyone had a color. So the reason I point that out is the client was also picking the color. So when the client got in touch with Varsity Brands, they picked the style from Varsity Brands styles, but then they would pick the logo and they would pick the color based on school colors, not based on creativity. So when you see the different colors on the samples that Varsity Brands copyrighted, the color, they're just random colors because it's the client that would actually choose the color of the finished uniform. So the creative choices were very narrow that Varsity Brands was making, and then you can see what they look like. So one of the things that cannot be copyrighted in the United States and in many countries is something that is functional, right? If something is functional, you cannot have a trademark on it, and you cannot have a copyright on it because functional things should only be monopolized by patents if and only if they're eligible for patents. In this case, it might be a design patent. But Varsity Brands didn't choose to go with a design patent. They preferred to go with copyright because it's much easier to get, right, faster, and then they can register it. And then they just kind of tested the waters to see what they could do. Well, in this case, those are the 5 designs that they copyrighted, the ones that dominated the portfolio because everyone wanted those. The company just, the colors get chosen by the client, but ultimately, the argument unsuccessfully that was made is that the cheerleader uniforms are functional. So what's functional about clothing, right? It covers your body, it hopefully fits you. In cheerleader uniforms, you want something body conscious, but still something you can move on because cheerleading is very athletic. So it needs to be designed for freedom of movement. But for the women, that's the women, not the men. I'll show you a picture in a second. The main function of the particular styles that Varsity Brands made were to make the female body look attractive. So that's what they chose. So these particular designs were specifically intended to make the person wearing the cheerleader uniform look attractive and look attractive in a sexualized way. And I have to tell you, as an aunt of two nieces that did cheerleading, when you see college kids or even high school kids wearing clothes that's supposed to make them look sexualized, whatever. But when you see little children like 7 and 8, 6 years old wearing these things that are supposed to make them look like adult women and sexualized, I have to tell you, I'm not a big fan of that. That's just a feminist point aside from the copyright, but that's cheerleading. That's the culture of cheerleading in the United States. So now I just have some examples. So at the top you see women and men, and they're both cheerleaders. I taught for 11 years at the University of South Carolina, and that's pictures of 5 University of South Carolina cheerleaders. And you can see the difference between the clothing the women wear and the men wear, right? The women, very, very short skirts, so you can see almost their entire legs. They have sleeveless tops, so you can see their arms. And then the panels up the side of the female uniforms are supposed to elongate the torso and make them look thinner, and then kind of draw attention to their having a nice figure. The men, you can see on top, the 2 men at the top and the man on the bottom, their clothing is completely different, right? It's comfortable. It's not tight. It's not showing their every, part of their body. They get to wear pants, and the pants are baggy. They're not clinging to their body. The shirts are, let air move. They're freeing. They're going to move around. You see the same thing with the guy at the bottom. Now remember, both these groups are being very athletic outdoors, and South Carolina is very hot. So the women, get maybe something cooler, but the guys get to be more comfortable, right? The women are wearing the short skirts. They have to worry about, awkward poses and then things being seen that they don't want being seen. The men don't have to have that concern at all because they have a completely different uniform. So the Varsity brand sold this, so it was only men or women's uniforms that were subject. The boys completely, t-shirts and shorts, and nothing about them, of the boys' uniforms, the men's uniforms, to accentuate the body. So that's the Varsity Brands case. And basically, I attribute the verdict of the Supreme Court to the fact that there were only 3 female justices, because I think women sort of understood the argument of the clothing better. But it turned out it was actually one of the male justices, Breyer, who kind of figured it out. In his dissent, he said, wait a second, this is all very functional. And I would also say, if any of you have studied design, like clothing design, the stuff that Varsity Brands did, it's like clothing design 101. It's very basic. Like black colors are, if you wear black, it's supposed to make you look thinner. Like that's a sort of obvious point. Or if you're not really, really skinny, you shouldn't wear horizontal stripes because it makes you look bigger. If you wear vertical stripes, it's supposed to be slimming. I think all the women, at least in this lecture, have heard something like that. Different fashion advice about how to make, whatever your body is, how to dress your body in the most attractive way. And Varsity Brands basically took things, design elements that make a woman's breasts look larger and her waist look smaller and accentuate the hips. They took some very basic design elements that are known to do that by people who study design and write about design, and they copyrighted them. So that left the competitors in a position of just not being able to make uniforms that people wanted to buy because they couldn't accentuate the body in the same way the Varsity Brands, because they effectively copyrighted something functional. Moving then quickly to trademark law. Trademarks, often if you look at the way products are advertised, women are objectified in advertising and branding. Also, in addition to gender, racially offensive trademarks were fairly popular in the United States, and so much so that they were challenged. So some different groups challenged racially offensive trademarks, arguing not that people couldn't use them on their products to advertise their products or even as an informal trademark. The argument was just that the US government shouldn't officially recognize racially offensive trademarks. So they were challenged. There were cases like Harjo that had to do with racially offensive marks involving Native Americans. And then the Tam case in which a band, it was Asian Americans who chose to call their band the Slants. And the word slants is an offensive term for Asians in America, but the band members, like Simon Tam, who led that, that's his name was in Tam, he thought that if he called his band the Slants, that he was reappropriating the word slants, that he would change the meaning and make it not racially offensive. That's what he wanted to call his band. So he tried to register the trademark. It was rejected by the PTO because the PTO said that's racially offensive, but it went up to the Supreme Court, and the Supreme Court basically said, hey, First Amendment, free speech, you can trademark whatever racially offensive thing you want, and that's, you know, that's the way we see the law. So that happened with racially sensitive trademarks. And then more recently than that even is the Brunetti case. And I'm sorry, I know this is an offensive word, but this is, you know, I have to say it to give you the nature of the case. In the Brunetti case, someone basically applied to the USPTO to obtain a trademark on the word fuck. Okay, and guess what? They won. So the Supreme Court said perfectly fine. It's offensive, very powerful word to a lot of people. No problem. So that was trademarkable. Racially offensive marks are trademarkable. So those were challenges. The trademarks that are offensive to women, no one has even really mounted an offensive challenge, and I don't think anyone will, because we know we'll lose. We just know that society doesn't care about women being objectified in trademarks, right? If they don't care about racially offensive ones, the idea that they're going to care that women, it's offensive to women, it's hard to be optimistic about that. Oops. Okay. Also, women and gender, this is kind of an important issue recently with what we have in the United States called the Black Lives Matter, and that is trademark, what I call trademark adjacent rights. I wrote an article about this a really long time ago, and I really want to revisit it, but it has to do with naming rights in the physical public domain. So when you have in the United States a university, the University of New Hampshire, for example, that's not named after any person, but then in our law schools, the University of New Hampshire Franklin Pierce School of Law. And it was named after Franklin Pierce because he was a president of the United States who was born in New Hampshire, our state, and grew up here. He's like the local guy. The house he grew up in is actually fairly nearby the law school. So when they named the law school, they named it after Franklin Pierce. Well, he was the president, he was from New Hampshire. It turns out he was also kind of a jerk, and he had bad politics. So that's something my law school is talking about right now. But basically, people's names get on universities or buildings or public universities, private universities, buildings, parks, streets. People's private names get put on these things, and they get put there in different ways. So the first one is they purchase it directly as sponsorship. So at many universities in the United States, whether they're public or private, if you have a bunch of money and you want to give the university a bunch of money, like let's say you have $1 million and you say, I have an extra $1 million laying around. I want to give it to this university where I got a great education or my kid got a great education. Often for $1 million, the university will be very happy to name something after you, right? It may not be a whole building. $1 million isn't going to buy a building, but maybe they use $1 million to retrofit a classroom with new technology and it becomes the Bartow classroom because I gave them $1 million. So that's almost transactional. It's a sponsorship. They won't say you can buy the naming right for $1 million, but to say, hey, if you give us $1 million, we will honor you by changing the name. So that's purchased directly as sponsorship. A company might just say, you know, be it transactional. Indirectly, it's like a reward for a gift. Or sometimes it's a consequence of male-dominated political process, by which I mean legislatures, sometimes Congress, US Congress, sometimes in states, sometimes just in towns, will often decide to just honor somebody by naming something, like maybe the new bridge they'll name. In New York, there was a bridge in New York that crosses the Hudson River. And recently, the governor of New York currently is this guy named Andrew Cuomo. His father, Mario Cuomo, had also been a governor of New York. So, you know, big political family, lots of money, lots of ties. And when they built a new bridge across the Hudson River, he got it named for his father. So it's the Mario Cuomo Bridge. He didn't pay $1 of his own money to get it named after his father, right? He used his influence as governor of New York and his friends, and, you know, that they got it named to the Mario Cuomo. So, and it can be even a small thing, even a small park, right? They decide to name it after Bob Smith because he was somebody's, you know, a nice guy, or everybody liked Bob Smith. So it becomes the Bob Smith Park. Well, that is what it is, right? There's a lot of class issues buried in you have to be basically usually rich and influential and have the right connections to get something named after you. But it turns out it's also better if you're a male because women almost never get these things, right? They don't get things named after them. So you can buy, even when you try to buy stuff, right, who's going to be honored when a woman is involved, a lot of times instead of naming it after the woman, they'll name it after the family, right? Instead of saying, you know, the Arlene Goldberg building, it'll be like the Goldberg family. So a lot of times the culture will kind of erase the names of women, right? So like at the University of South Carolina, we had a big building called the Strom Thurmond Field Center. He had been a famous senator. And then there was a woman who gave a ton of money. She's very successful businesswoman who gave a ton of money to the business school. Her name was Darla Moore, and they didn't want Darla in the name of the business school. So Strom Thurmond got his name in. His first name was Strom Thurmond, but when it was Darla Moore, they just made it the Moore Business School, because like calling it Darla, they were uncomfortable. It sounded too girly, and it might not be good for the business school. Right now, the Black Lives Matter movement and some other things that are going on, a lot of public statues are also being challenged, like memorials to the Confederacy and the US Civil War. And a lot of people are challenging them because they represent racist values, really bad values. And that's a great reason to challenge them until they're being torn down or replaced, and so on and so forth. At the same time, there's a total lack of women. So there aren't really women's statues being torn down because we never had them in the first place. But I hope as we begin to rebuild our public squares and have a better dialogue about whose name or whose statue should be honoring people, that women will be a bigger part of that. I hope that in the future that will be so. And even though I'm calling this trademark adjacent, of course, there's an overlap with architecture, with copyright works, right? Architectural works, buildings that we might name after somebody, and pictorial, graphic, and sculptural works, the plaques, the sculptures, the paintings, right? The paintings of the famous professor or the dean that hang in law schools. All those things women tend to be grossly underrepresented in. And then I'm going to end by just talking about artificial intelligence and robots for a few minutes. Robots have artificial intelligence and robotics. Robots have a lot of gender indicia for different reasons. I also want to say there's a lot of fantastic work in the United States being done about artificial intelligence and algorithms. There's a lot of really smart women scholars actually writing about gender issues with algorithms. So I'm not going to really talk about that, but I will say if you're interested, there's some wonderful work being done. So robotics, it turns out that robots, human beings generally prefer robots with human characteristics. They find the characteristics very reassuring. But as I probably don't have to tell you, there's no reason for robots to have a gender, right? They don't breed, they don't date, or I guess they could if we program them to do that. But there's no real reason as a functional matter that we need any robots to have any gender, right? But it turns out that even among robots, no less among living people, androgyny makes people very uncomfortable. People insist, they just feel this need, a very powerful need to know gender. Of babies, of dogs, of anything. They always want to know what the gender is, and it somehow just overlaps with robots. That androgyny makes people uneasy. So what we see in the culture then is actual gender policing of robots, that robots are policed for gender norms, that people want to see female robots do female associated things and male robots do male associated things. They want to see gender norms associated with people with respect to appearance, names, design, and function. They want to see that in the robots. And then once that happens, the gender designation affects their perception of robots. So male robots are perceived as smarter, while female robots are perceived as more caring, even though they may be the identical robot, right? One of them is wearing a blue t-shirt, one of them is wearing a pink t-shirt. If you look at people's perceptions, it will be that they are different because they have different genders. Male robots are associated with the following: soldiers, right? Robotic soldiers, like think of Star Wars and different things, robotic policemen. War machines, generally, weapons are seen as male. For some reason, drones are seen as male. Again, other kinds of weapons, nuclear weapons are seen, tanks. And then cars. Cars are also seen as male. That's the one that surprises me the most, but yeah, cars are also seen as male. However, when you think about robots, right, do you want a robot in your home that could strangle you or electrocute you in your sleep, right? So when you think about having a robot in the home, and then you think about these stereotypes of war machines, weapons, and soldiers, how much do you want that robot looking after your children? Maybe not so much, right? That's kind of a scary robot. Female robots, on the other hand, are associated with caretaking. Robots have been designed to keep old people company. If their family doesn't want to visit them and they're lonely, they design robots, and they tend to be female because they're caretaking robots. Kitchen appliances, child-related accessories, cleaning equipment, and also the voices. You can tell me how it is in India, but in the United States, Siri, which is the helper for Apple, or Alexa, and I have to be careful because I have Alexa, she's going to talk if I'm not careful. Alexa is associated with Amazon smart speakers. The Google smart speaker has a female voice. GPS to use directions. GPS, sometimes you can change the voices in some of these things, but usually it's a choice of mostly women. and a few men, because if somebody's going to help you, we just as a society want to have it be a female voice. That reassures us. Okay, so that's all well and good, but will your Roomba back you up in a fight with an intruder, right? If you have a robot in your home to do caretaking and a criminal breaks in, right, and you have some kind of problem, your Roomba is all very passive and associated with vacuuming your floor. That may not, suit your purposes. So these gender stereotypes kind of get in the way of the all-purpose functionality of robots. Then we get to something that's complicated, but it's seems to be a function of human nature, which is robots as sex partners. Because the minute the first robot was built, apparently, someone looked at it and said, it looks like a human, let's have sex with it. Like, let's figure out how to have sex with robots. So robot sex partners are a huge industry, very curious kind of industry, but they make a lot of money and there's a lot of popularity with the products. The problems, there are some problems with this, and let me talk about them. So first, they're designed strictly for human pleasure, which is not a bad thing, okay? I'm not down on human pleasure, that's a great thing. They're completely controllable sex partners. So far so good, right? Next thing is they can perform in ways that humans cannot, and there are no consent issues. So you would say that's good, and that's also good. If people have certain desires and other humans aren't really interested, the idea that people can satisfy these desires with robots where nobody gets hurt and there's no consent issues is also kind of reassuring. And then next, robots can have fake autonomy in bed if that's what the human controlling it wants. In other words, if you want a robot that says, not tonight, I'm not interested, you can have that. That's what you can program a robot to say, I'm not interested in you tonight, or you're take a shower, or I don't like that clothing on. You can program your robot to do whatever you want. But here's where things get concerning. So the sex continuum for robots is from wild to frigid, with frigid designed for rape role-playing, okay? So there are some legal questions about whether you could actually rape a robot because robots are property, they're not human. So probably that would take legal changes, but there might be some laws about personal property that might apply if someone treated your robot in a way that you didn't want them to treat it. But my concern is in the final part, which is this. What is the effect upon humans, right? After one human has been having sex with a robot who's completely controllable, there's no consent issues, and does whatever you say, how does that affect the way you see humans when you're going to have a physical interaction with humans, right? If robots don't have to consent, there's the danger that robots create a change to consent norms, right? Norms of consent, norms of expectations. Pornography has been shown to have effects on people. The way men see women has been shown to be affected greatly by pornography. Would robots do the same thing? And then the one thing I will say in favor of robots in turn is an outlet for culturally legally deviant sex acts. And just as an example, on pedophilia, like I feel kind of sorry for pedophilia, people who are pedophiles, because no one would ask to be born that way, to want to have those desires, because it involves children, it's illegal, it's amoral, it's horrifying, right? Anyone who wants to have sex with children, I think, is very horrifying for people. So the argument has been, what if they had a child robot? Would that help them deal with their desires and keep children safe? Maybe, or maybe it could have the opposite effect, I don't know. But there's a lot of things to think about. That's, I guess, sort of my major point. There's a lot of things to think about that, and I certainly don't have a lot of the answers. Research needs to be done. But I leave you to the question, should robots, what about gender fluidity in robots, right? How would we feel about a robot that could actually switch its gender identity and its gender performance, and would that make it more acceptable and useful to humans? In other words, you could say, okay, clean the floor, now it's a, put on as a female robot, and then, do security, it's suddenly a male robot, or, something along like mow the lawn, now it's a real male robot. Just a question, would gender fluidity be something that would be, how would that affect society, and how would people react to gender fluid robots, I think is the question I will leave you with. And now I'm open for questions and comments.
Thank you, Professor Ann, for a wonderful, reflection of the feminist gaze, which is not usually in many of the discussions. So we have been able to look or approach it from a very, very different perspective, which you have provided. So not only theoretically, but you have provided it in a very practical and, you can say, very prevalent manner, which is very much aligned to AI discussion also. So that gives it a very, diverse flair, so to understand. So I invite Professor Raman Mittal, our professor in charge, to give his reflection over your speech and anything else which he wished to add. So, sir. Yeah. You unmute, sir. Yeah.
Hope you have to unmute.
Okay.
I
Okay.
can't hear.
Yes.
Okay, thank you. Am I audible now?
Yeah.
Yes.
Okay. So friends, as we have just finished listening to the erudite discourse of the distinguished speaker, I would also like to say a few words about the feminine and creativity. Existence is essentially dualistic. This is the way things are. The enormous dance of universe is going on seamlessly with the two principles that are indispensable and are equal and are opposite. Among scholars as well as lay people, discourse on women's place in the family and society and opinions on women's issues are inspiring a sense of rediscovering the mysterious inner and outer working of women's power and energy. Throughout the centuries, however, women's strength and qualities, instead of being appreciated for itself, have been largely ignored, taken for granted, or outright exploited. Despite much advocacy of women's rights, women have not yet achieved the power to influence and control their own course of life. Their efforts to overcome impediments to freedom and equality have made very little inroads in raising the human consciousness worldwide, making their vision even more elusive. This is evident from various statistics presented by Professor Ann just now. The current century has the potential of women achieving equality, but only if they recognize the significance of what Naomi Wolf calls the historical self-awareness. Women are today at a turning point, what historians call an open moment. A lot more women are shining at professional levels of great diversity, from aerospace to businesses, from corporate leadership to politics, from sports to science and technology. In this context, feminism need not remain just a label. It must become a way of life. This, however, is possible if women do not become indifferent to their role and responsibility towards history. Dissent and disagreement shown by women across the whole spectrum of human life need not be a reactionary phenomenon, but rather a healthy sign of diversity, strength, and, more importantly, creativity. The Chinese mystic Lao Tzu has given a remarkable insight. He says, the nature of existence, the environment around us is more like a female. Lao Tzu is not saying that existence is female. He's not giving a slogan for any particular ideological movement. He's actually pointing at a certain quality. He calls it the creative principle. The creative principle. Like Earth, a woman is a creative principle. Miss Shirley MacLaine called for more of the feminine spirit like this. That is intuition, patience, foresight, caring, and nurturing. The spirit which is so important and seminal to creativity. However, men and women are equal, but not similar. They need not be. Lesser the polarity between men and women, greater will be the possibility for a creative tension. They are unique in their own ways. Both need equal opportunity, an opportunity to grow. Women's uniqueness must be recognized, respected, and supported. A woman must have equal opportunity, an opportunity to develop her own qualities and thereby evolve herself. And as Professor Ann Bartow said, one is not born a woman, but becomes one. This redefining of feminism therefore depends not only on women rediscovering themselves, men will also need to redefine their role and restructure their attitude vis-a-vis women. We need to liberate both men and women, both male and female, from their age-old conditionings. And if a society can be created in which men and women have participated equally, that will be for the first time the richest society in the world. When male and female energies meet, it becomes a circle, and only when both the energies come to their fruition does a rhythm arise. This rhythm would manifest itself into more and more creativity, and that is exactly what we want from copyright, more and more creativity. Friends, we are indeed thankful to Professor N. Bartow, Professor Franklin Pierce School of Law, for her wonderful discourse. She has taken us to a very interesting journey into copyright law with a feminist case, and also some snippets of trademark law as well as patent law. We are from Campus Law Center. We are extremely grateful to you, ma'am. And now I would like to invite Professor Alka Chawla, my distinguished colleague, to ask you a question. She wants to ask a question to you.
Great.
Yeah, please unmute Professor Alka Chawla. Kshitij, I think
Yeah.
you need to unmute her.
Yeah.
Yeah, you're unmuted.
All right. Thank you, Professor Ann. It was wonderful listening to you. I think a perspective which I also as a woman had not thought of. But I have just one or two observations to make. First of all, you talked about negative spaces, especially gardening, recipes, etc. There, if I'm not wrong, in United States, there is a requirement for fixation. So when you have the fixation requirement, which I think is a gender neutral requirement, so in that case, it would be very difficult to say that recipes to be, copyrighted, or even gardens for that matter. And when you especially talk about makeup in the beautician field, where more women are working than men, and then you don't have the copyright laws. In such situations, unless and until it is like clowns, we keep reading about clowns, they paint their faces on the eggs so that they can be copyrighted. Unless and until it is something very distinctive, unless and until it is something very creative, don't you think copywriting, makeup, recipes and gardens, etc., would rather act as a hurdle for the growth and progress of the cultural and the social progress in the society? One, that, and secondly, with respect to the trademark law, while you were talking about the cheerleaders, etc., I completely agree with you on the kind of observations that you had made. But one thing, like for example, in our Trademark Act, we have there's something which is called absolute grounds for refusal of registration of the trademarks, and there one of the grounds is scandalous and obscene matter. Now again here, as the pictures shown by you, and we completely agree, it is more for the pleasure of the men's eye than the woman's eye. So you have the dresses designed like that. But it would all depend upon, like as Professor Raman was saying, that we need to redefine the male and the female roles, and the male and the female eye that needs to be more gender neutral. In that kind of a situation, maybe time is not far when obscenity and scandalous behavior, or scandalous kind of costumes, they may not be they may not be registered as trademarks. So with these two observations, I would again thank you for a very brilliant and a very lucid and very interesting talk. I normally don't sit for webinars. I feel there's nothing much, but I'm very thankful to my own self and to Campus Law Center that I decided to be a part of this webinar. And thanks to Professor Raman and Kshitij to bring you here right in our home to talk about such things. Thank you so much.
Well, I'm really glad to be here. Thank you for your great comments and questions. And I'm glad you made it. I'm glad you gave me a shot in your webinar. So you brought up a lot of really interesting points. I'm going to start with, it's kind of an intermediate point, but it's the one I think is the most important from my perspective, which is when you said, if we had stronger copyright on the negative spaces categories that I talked about, would that actually be a good thing? And I have to agree, probably not in a certain respect. Like my view of copyright generally is that lower barriers leads to more creativity. That when people write when a song springs into somebody's head, they don't have to do a whole lot of research to make sure nobody else wrote it. You know, they can feel more free to create stuff and kind of figure things out later. So my general philosophy is that weaker copyright is, I mean, I believe in copyright, but weaker copyright is generally better. The problem is, if that were across the board, I would be happy. The problem is when we have negative spaces associated with women, what are they missing if we don't have copyright? Money, right? If you want to make money, if you want to be rich and powerful and have your own publishing company or have your own fashion house, you need money. And the way that you get it is partly, at least, by leveraging intellectual property. So I think when people share recipes and things, I think that's a better society. But the reality of our society is people were going to take other people's recipes and put them in their restaurants and try to make as much money as possible. And I guess I would just like, if that's the world we have, I would like to see more women making the money, because I think that would actually lead to changes. So I'd like to see more women being the famous chefs and more women heading the fashion houses. So yeah, so it is kind of bifurcated, right? On the one hand, I have my perfect idealized view of society where people share, and I think it sounds like you agree with me at least a little. But on the other side, as long as, you know, intellectual property is really all about money, at least in the United States, and very little about the artists and culture. As long as that's the case, I would just like to see women get more of the money and hope that they invest it, you know, in businesses and things with other women. You also brought up fixation, and that's a great question, but it turns out, like for men's stuff, fixation isn't a problem. And just to give you a couple examples, there's a thing that happens in the United States in beach towns where they have contests for sand sculptures. So famous artists come and they build big outdoor sculptures of sand, and they copyright them, and people take pictures of them, and then a wind or a wave comes and takes them away, and they still get copyright. Another form of art, especially where I live in New Hampshire, the winters are very cold. So people make ice sculptures, right? So we have all over town outdoors, people make big, beautiful sculptures out of ice and then light them up, and they're gorgeous, but we know they're gonna melt as soon as the weather gets warmer. So for things like that, and for gardens and for food, photographs, just like the clown eggs that you talked about, photographs will often capture enough to sort of, for evidentiary purposes, establish a copyright that can be defended. But you're right, those are the hard questions. I mean, the fixation, and in fact, with the garden case, that was fixation was the basis for which copyright was rejected, right? So that's definitely true. I think generally, when you talked about the trademarks too, I think India, the cultures, I'm not as familiar, I'm fairly familiar with Chinese culture around these issues. I lived in China for a year. I did a Fulbright in China. In the United States, I know a little bit about India and other cultures, and Canada, another culture I know fairly well. Social harmony is just more valued than it is in the United States. Like basically being polite to each other and being harmonious is just more important in other nations. And I like that. But in the United States, the idea of free speech and people being able to say whatever they want, even if they offend lots of people and hurt people's feelings, right now is the predominant right. The First Amendment seems to trump almost any right to be comfortable and not offended and not have, you know, racially disgusting trademarks or offensive things to women. The First Amendment right now is just the most valued right. And that's different, I know, than other countries, other continents, where people's feelings are taken a little bit more into account.
Thank you.
So there is another question. Can I take it? This is from Palka Rishi. Says, making an observation that it is not only acquisition of IP or copyright that may have sexist overtones, but also its subject or misappropriation. For instance, from a historical perspective, the subject of painting or portraits for decades have been women, but there have not been sufficient number for the female artists. And the other question, which is just aligned to it from her only. Furthermore, misappropriation of traditional IP has led to creation of some sexist stereotypes. For instance, the constant use of the Native American headdresses on scantily clad female models in editorial photos particularly by brands like Victoria's Secrets, has led to over-sexualization of Native American women.
Yeah, I mean, I completely agree with that. And the point, just to start with the point about the paintings, is a really good one. It's not unique to the United States. A few years ago, I was lucky enough to be in Florence, Italy, getting a tour of the Uffizi Museum, which is a fabulous museum filled with fabulous paintings. I was lucky enough to get a tour, and it turns out there's all the paintings on the Uffizi, one of the most famous museums in the world, one painting was done by a woman. But at least that was there, right? Because some museums don't have any. And a friend of mine who does art history made a joke at the Metropolitan Museum of Art in the United States, which is in New York City. It's kind of a big deal. She said that the only way women get into the Met is naked, right? Because what she meant was posing for men, right? If you look at the paintings, the men are the painters. The subject is also the woman, often the woman, and the woman is often naked. So if you want to get into the Met, and you're a woman, if you're a man, you can be a painter. If you're a woman, you have to be naked. So that's definitely a point. When you talk about the trademarks like Victoria's Secret and the sexualization of women, it's absolutely true. And you know, trademark law just is like, the trademark law as written is basically hands off. Like, that's not our problem. And when people were making the racially offensive trademarks, people said, that's a problem, right? That is a problem, that is your problem. So they litigated it through the courts for many, many years. And then the Supreme Court just said, nope, first, free speech is more important. Right? We're just not gonna worry about it. So yeah, it just reflects our values, the way intellectual property falls out, and I think in any nation, it reflects our values. And maybe that's why harmonizing is kind of hard sometimes. Like when the United States adhered to the Berne Convention, one of the big things we were supposed to change about our copyright law was we were supposed to have moral rights. Well, I can tell you that's, you know, almost 30 years later, we don't have moral rights. We agreed that we would, but we don't, because our culture is just, we just don't, you know, the culture of giving power to an author just is not part of what we think about. We want to give it to people with money, right? The people who own the thing, who paid a lot of money for that painting, they should have all the rights, not the painter. So you do see the culture, and then I don't know, cause and effect, like with the gender stuff in copyright, is it, the discrimination comes first and then the copyright law, and then does the copyright law sort of reify the discrimination? Are we kind of caught in the cycle there? But definitely with copyright, you see our values in our laws and how we enforce them, for better, for worse.
Yeah. So any further question from anyone? There's a very elaborated question, so I mean, so can you ask it, Sabaj? I will unmute you. Are you there? I can read it.
Okay.
So Fearless Girl is not the paragon of feminism that some have claimed. By portraying women's career empowerment with an image of a child and focusing exclusively on the incremental admission of a small number of women into traditional halls of power, instead of addressing systematic issues impacting women of all socioeconomic backgrounds, the girl hardly constitutes a broadside against gender inequality. So this was stated in the article, Copyright Male Gaze. What's your take on this?
Yeah, so I guess I have kind of mixed feelings, because I think on the one hand, well, I think you're right, but mostly I agree that the systemic issues are the most important ones to tackle, absolutely, for sure, that's what we need to do. But and I'm not saying necessarily Fearless Girl is it, but I do think we also need symbols. Like, I think we need symbols to motivate us as well. So when we do see the women who succeed at the highest levels, women on the Supreme Court, women in running corporations, that is inspiring, and that's important. We have a woman for the first time in my lifetime, we have a woman running as a vice presidential candidate who has a real shot. I don't know if she'll win or not. We had two. Geraldine Ferraro ran when I was a kid, and then Sarah Palin ran a while back. So we have our third vice presidential candidate, a woman, but she has at least a real shot. So that's very exciting for a lot of women. It doesn't change anything for us, right? But just to have her there, I think would be very, very inspiring and would be great for a lot of reasons, but it doesn't change things systemically. I would actually, this is a little bit on one side, but for all the men in the audience, I'm gonna ask of you a favor. There's something that happens in academia a lot, which is we have panel discussions about legal issues. And at least in the United States, all too often, some of the panels will wind up being almost all men or all men, right? And so we have a word for that. Instead of panel, we call them a manel, M-A-N-E-L, right? A panel of men is a manel. So my challenge to all the men on this call, on this presentation, the seminar, is don't go on any manels. If you are invited to a panel and you see that it's all men, then you say to the organizer, we need at least one woman on this panel if you want me to talk, that I will not talk on a panel. I will only speak on panels that have at least one woman. If you would commit to do that, at least 80% of the time, you don't even have to, so if you got a really heavy gig, you want to do it, whatever, okay? But if you would commit to doing that 80% of the time, you would start to make systemic changes in legal academia. Like that's a very, I think, relatively simple, straightforward thing you could do that would help women and address some of the systemic discrimination like in our field that we have.
Okay, so just a conclusion for all our discussion. I will just put it in a few words. So a few things, I was also observing that it is not, restricted to women only. If you take the Black Lives Matters movement, you will find that if you take the case of patents, so inventions are going on for a long time. And there was a time when they were slaves, so they didn't have that right to, claim inventorship. But what happened after that very slavery has been, abolished? Even then, they are not being in that much number as their counterparts. So that is another, purview to look into. And I think that, as you mentioned, it is the matter of perception rather than any other, tool or technique. Because if you see ideally, none of the intellectual property rights are inclined to a gender. They are very gender neutral in that sense. But whether that is enough, empowerment itself talks much about that. Just, bringing an equality on the paper is not enough. You have to make that thing happen. And how can you make that thing happen? As you said, that by having this very realization that in the group when you are going or you are, participating, whether there are fair amount of fair number of those women or not. That is the main thing which we have to look into. Next thing which you have pointed out is very, very, significant regarding two cultures like in US or in India. So in US, as you said, that people are more enthusiastic about claiming their rights, or you can say asserting themselves that this is my freedom of speech and all that. So in India, things are there, but there is another way around where people may be asked that you must be sober. So when you ask anybody to be sober, you must not, shut him up or her up. You have to encourage that if you do have any concern, you should come forward. So whether we are aligning to that very process or not, that we have to think. So your lecture will provide, or you can say ignite those minds in our faculty, as ma'am has said, Alka ma'am has said, and Professor Raman sir said. So we will be benefiting by starting something, by taking this very, movement forward, if I say movement in that way, because we were not looking intellectual property right from this perspective, but we have to look at, because if you just remember, I'm just taking 1 minute more. If you remember that 2 years back or 3 years back, the World IP Day theme was just empowering women and women entrepreneurship. Why? Because they are half of the population. So if you are not inclusive enough, this is a loss. This is a national loss. You are not triggering them that they must be a part of that very process. So in that way, feminism or feminist gaze is not only important from that very academic discussion, but it must be inculcated in that very process. So thank you so much for, being with us and, just triggering various new thoughts among us. And on behalf of Legal Aid Society, and I'm proudly saying that our Legal Aid Society is being headed by a woman only, Ms. Baresi, who has made a great attempt, in organizing this very program. And we always look at it. I mean, I always pay heed that how many women are there in that very committee or not. So as you said, we will follow that. And on behalf of all my colleagues and my professor in charge, my senior colleague, Professor Alka ma'am, I'm very much thankful to you, and I'm looking forward that I should invite you in a different perspective or to talk about on different issues. So thank you so much.
Well, thank you. And I'd love to hear if people research this further. I would love to hear what you come up with. And I would love to learn more about India.
Yeah, thank you. Thank you so much. Sir, if you wish to say something, you can. Okay. So thank you so much. I'm just stopping it here and we get connected.
Wonderful.
Thank you. Thank you, sir.
Thank you. Thank you for your attention and interest.
Thank you.